There, there are different kinds of SBA loans. Now, you may get calls being like, I have an SBA loan and I need to know what to do about it. Or I have an SBA loan. And then you ask, well, what kind of SBA loan? I don't know. So just for your general information, there are, you know, there are separate categories of SBA loans. 7A loans are usually used for equipment or a specific piece of machinery, and it's usually tied to some kind of collateral. Um, some I've seen on rare occasions, 7A loans can be used as quote unquote startup loans, but even still, there's typically some kind of asset that is tied specifically to the loan. Another kind is 504. These are long-term fixed rate. They can also be used for equipment, machinery, and assets, but with those, you tend to see a longer fixed rate term, and the proceeds don't necessarily have to be used specifically for purchase or maintenance of one piece of collateral that the loan is tied to. So with 504 loans, you may see blanket liens.
Well, and I just, one of my clients just got a 504 loan, and they made sure that they secured that thing. It was like, lien on the house, lien on, the blanket lien on pretty much everything. And I mean, it was just, if you get asked to help with a closing of an SBA loan and be the attorney for the borrower, get paid. Because I thought this is going to be no big deal. And we closed in August, and they're still, after we close, they're like, oh, by the way, can we get this? And they're funneling the money to my client for tenant improvements. And so they're holding that over our head. So even though we signed everything and they said they had all the documents, they're now like, but really, we would like this. So it's just, so understand it's not, I mean, closings, in my opinion, are never easy for anything, but this is particularly obnoxious, especially because we're dealing with the lending partner, which is the bank. So the bank is referring things to SBA. SBA is sending back their mandate to the lending partner. So there's a lot of attorneys involved. And then the bank that they decided to use was out of Rhode Island. So then they had to get local counsel. So there's a ton of attorneys getting paid, none of which were me, which was kind of a bummer.
I mean,
Go ahead.
that's kind of par for the course for consumer bankruptcy attorneys.
Right.
Everybody,
I was staying true to my calling.
all right, so the other kinds of loans are physical disaster loans or some variation thereof. So think of the PPP loans. That was a specialty disaster kind of loan, but not a natural disaster kind of loan. That brings us to economic injury disaster loans. So this happens when there is an event which causes economic injury. This is usually after some sort of natural phenomenon or uh, natural disaster or, like a pandemic or something. So for example, they're localized. They're localized to the area where the natural disaster has been declared. So the COVID EIDL loans, which is what we're going to be talking about the most, those were, of course, for everybody because the pandemic was worldwide. But shortly after those loans, San Diego County, where I am, we got more rain than we're used to. And guess everybody freaked out. Oh my God, there's rain, there's water. What do we do? And so that was declared a flood, and San Diego County businesses became eligible for EIDL loans to deal with consequences of the flooding. Or honestly, there's not a lot of underwriting for these, so it was more like, hey, there was a flood here, um, and there's been economic injury to the economy here, And can we have some money, please? And the SBA is like, yeah, sure, here's some money. All right, next slide. So we talked about this briefly. The Paycheck Protection Program and COVID EIDLs, what they have in common is that they were only available for a specific
Oh,
short
sorry.
period of time.
Sorry, I'll go back. There you go. Sorry.
Oh, no worries. So most of the PPP loans were either subject to forgiveness or they had already started the collections on the ones that, on the rare occasions where they were not forgiven. EIDLs, on the other hand, everybody wised up when people started defaulting on those because with the initial EIDLs for COVID, repayment did not start right away. It was only when repayment started that people started defaulting. And so I don't know about you, Lisa, but the majority of the defaults that I start like when I started seeing them was around January 2024.
I would agree with that.
Yeah. So what do we do with this? What is the SBA
I
going to
mean, and
do?
it's a lot of money. And
Mhm.
most of what you guys are going to see are COVID EIDLs, but possibly, in the future, there could also be EIDLs, but for our purposes, it's probably just COVID. So today, there's non-EIDLs and then there's EIDLs. Um, and it's very different how you deal with them. Like I was just saying that we keep non EIDLs have, much more collateral and various things that, they have a banking partner and all of that good stuff. And there are offers and compromise that you can do with them. But EIDLs, there's nothing except bankruptcy that really gets rid of them. So I don't think we need to spend a lot of time on the slide, except you guys should go and look. These are the terms of basic terms for various for the EIDLs. And we got this from, in fact, the presentation that we did with the two US attorneys for SBA, and I think we did it a year ago, maybe 2 years ago, Gil Hoppenstad and Anne Manili. So this is where we got that slide. Um, Personal guarantees are not supposed to um, be imposed on any EIDL, COVID EIDL of $200,000 or less. And there's not supposed to be any kind of personal guarantee for a nonprofit. Um, and Milie, do you kind of want to address what you're seeing as far as personal guarantees on um, the loans that are under 200,000, kind of what we
Yeah.
were talking about?
Yeah, and so also to address this slide, so that's what they're supposed to be, right? Any EIDLs under 200,000 are not supposed to carry a personal guarantee. Nonprofits not supposed to carry a personal guarantee. I don't know if you guys have had a chance to actually read any of the loan applications or the loan documents once the funds are issued. Um, None of this about the parameters is mentioned in any of the contracts, whether it be an EIDL loan for 10,000 or an EIDL loan for 500,000. The loan documents are very similar. So that leads to the question of, well, how do you know one has a personal guarantee and the other one doesn't? You don't. On all of these loan applications and also the loan agreements, the very last paragraph before signatures is typically along the lines of any uh, any borrower or representative of a borrower who affixes their signature below is jointly and severally liable as a borrower on this loan. So if someone signs as you know, John Doe for ABC Inc., there is significant question as to whether John Doe is personally liable on that loan. From the plain language of the loan document, yes, John Doe affixed his name below, and John Doe is a borrower. He's considered a borrower under the definition of the loan agreement, and he is a personal guarantor. What has the SBA led everybody else to think? Oh no, only if it's over this certain amount.
Well, and I'm actually doing a dissolution for a nonprofit organization that does have an EIDL of over 200,000, and they just could not make it work. And so we're doing a dissolution for them, and they were told by SBA during the pandemic that there's going to be no personal guarantee, yet the documents they sign do have some, in my opinion, some very vague and generic personal guarantee language. And until we started the dissolution, they were just getting notifications to, the president of, the executive director of the nonprofit. Now, because we're in default, because we're not paying them, the SBA is contacting everyone that signed either for an extension or anything like that. And I was just telling Millie, and she's had this same experience. They contacted me, and which is fine because I'm the attorney, and of course they should contact me by phone. And as part of that, they emailed me and said, we're going to contact you by phone and your client needs to sign this release. And this was last night. The release that they sent, it says it's not just and they copied my client on it, by the way. And it says, this is permission for SBA to talk to, pretty much anybody and get, I will allow SBA to have access to my personal bank accounts, all of this information that's super invasive and they shouldn't be providing. What was your experience with that, Millie?
So my experience with this, it's supposed to be a release so that my client is giving, a release for me to be able to talk to the SBA on their behalf. That's what it's supposed to be. That's what they describe it as. But when they actually send it out, it is never one thing. It is never just what was discussed. There is almost always a separate part of it where they are seeking additional financial information or access to financial information, not just for the business or the business entity that loan proceeds were given to. It is also for the individuals who are part of the business. And so that's what Lisa was referring to, where the form that that was received was not just a release. I mean, that can be a one-page document. Yeah, you can talk to my attorney, sign, here you go. No, it's not. How many pages was yours, Lisa?
It was just a very full, like short margins, one page. But I mean, it
Okay.
was a lot. It definitely wasn't just like you can talk to Lisa 57 ways. It was, we are. And the good news was my client didn't sign it and send it back to them because they sent it to my client. So by the way, they know he's represented or the organization's represented, and they send it to him. And luckily he's super savvy. And he said, I'm not signing this. And I thought, whoa, I didn't even send it to you. And that's how we figured it out. So I'm fearful about my nonprofit because I wonder if they're going to come back, and say that the board of directors or whoever signed is actually personally guaranteed on it. All
And
right.
a little bit later on, I'll explain a different kind of form where they tried to sneak in the same authorizations and information. All
Okay.
right. So what happens if an SBA loan is not paid? So I will say, going back to this is changing weekly. And what we thought was the process a year ago may not necessarily be the same process now. And that's, a lot of it's because of circumstantial issues like, okay, government shutdown, SBA funding being cut, employees being cut. So the dates and timelines that we have listed here, they may not be the same. So, starting at the top. All right, defaulting on the loan. What happens if you don't pay it? Well, obviously, not paying on the loan is some sort of default. But do pay attention to the language as to what constitutes default under these loans. It is so broad. You could sneeze in the wrong direction and be in default of an EIDL loan. But generally speaking, if the loan has not been paid for 90 to 120 days, then the SBA sends out a notice saying it's going to be transferred to the US Treasury Department. And then but it doesn't notify you necessarily when it has been transferred to the US Treasury Department. So the Treasury then usually adds in about a 20 to 30% surcharge as a collections cost, and then they are given the responsibility of instituting collections. Now, how are they instituting collections? Are they filing lawsuits for collections? Are they, doing the same procedures as the IRS? We don't necessarily know yet because they haven't really, I don't know about you, Lisa, they haven't really pursued the collections actions yet.
Yeah, and most of mine that I've dealt with, we haven't gotten that far yet.
Mhm.
And I was just dealing with them by filing a bankruptcy because that's the easiest way to get done if you have the right facts. With my dissolutions, I haven't I haven't seen yet what's going to happen. And I mean, the fact that I have someone from SBA after the shutdown, because I thought I'm not going to hear from them forever. And like, when did the government open? Like, what, a day ago? And they're calling me, and I got an email. Like, it's a little worrisome. I preferred when they were crickets chirping.
There's still, but that's the thing, it's different for everybody because it's still crickets chirping for me.
Oh,
Um,
so I'm just special.
yeah, you made an
Hey,
impression. They want to talk to you.
they were like, hey, there's a nonprofit we can harass. Excellent.
So, I mean, so that's what happens when you don't pay the SBA loans. But what are your options? I mean, because that's what clients come to us for. Hey, we have a debt, we can't pay it. What are our options? So with non-EIDLs, figure out how to pay the debt or sell the collateral that the debt is tied to and use that. Or um, they do offer and compromise programs for non-EIDL loans. And then of course our favorite is bankruptcy discharge because hey, nothing stops liability to a federal organization like a federal bankruptcy court order. Better, except for tax. But for EIDLs, there are no offer and compromise programs, and there are no official hardship programs. To my knowledge, there has never been an offer and compromise program.
They say
Um,
there is, but
Right, and the limited hardship program
who,
was eliminated in March.
right.
And before that, it was more of a deferment type of hardship. Pay a percentage of your monthly payment for this amount, and you were able to renew it up to 4 times, but not anymore. So that's the official stance
I
on
do want to mention
hardships.
have you done offers in compromise for non-EIDLs?
I have.
So, I've done them. They are, have you had success with yours?
They're difficult. They are very
So
difficult.
that is what I was going to say. They're incredible. Like people are like, oh, let's offer and compromise. They are really hard, and you're dealing with the bank, who is, the go between you and the SBA, and the bank's not going to fight hard for you, and the bank's been paid, and also you have to you have to submit the OIC to the bank, and on the one of them that I had, we couldn't even find a contact at the bank. And this was a non-EIDL because that's the only time they're available. And then they wanted everything under the sun. And, we made a good case for, my clients couldn't pay what they wanted them to pay. And they were like, no, they like that was a response. So, anyway, uh, so one of the things that I do want to say about this slide is clients are going to call and say that the business needs to file bankruptcy, and that's not really what they mean. I bring this up because you want to talk to your staff about, hey, if someone calls about that, don't necessarily turn them away because you think they want to file a Chapter 11, because usually that's not what it's about. They just want out. And so it may be worth, whoever's handling your phones to take a little bit more time to figure out, okay, well, that's not really what they're talking about.
Just a practice pointer. My staff, and then yeah, my staff has been trained as soon as they hear SBA to set it for a paid consult. That's how, if we didn't do that, I would be sitting around all day doing free consults and never being able to pay for the lights above my head. So please do not feel bad. I
Nice
know,
segue.
yes, I know as consumer attorneys, we typically, have bleeding hearts and really, really empathize with our clients and the hardships that they're going through, but you are going to spend so much time trying to get to the bottom of what the SBA loan is, what it attaches to, what the status of the business is, what, if anything, is secured. You deserve that consultation fee. At least get paid for your time that you're meeting with the client, because you are going to be putting in almost as much time on your own getting ready for that console.
Well, and also my cases never went quickly. There's always a lot of, no matter what we were doing, there was a lot of strategy, there was a lot of planning, there was a lot of bankruptcy planning. So you really should have like the investigation, get paid hourly. There's no way to flat fee this.
Yes.
And you can always apply the fees to, if it's just an initial consult, and then you file bankruptcy for them if you want to apply it. But I also found that it got rid of the tire kickers who
Hmm.
wanted to waste my time. Like, oh, it's just a quick question. I mean, that generally means pack a snack.
Right.
Um,
Right.
the
So there, I
Also,
did, I
go
did see
ahead.
a quick question. I know we're saving questions, but just to answer, um, Frankie, answer your question. Yeah, hourly. I break it up into half hour or an hour, and then for follow up, they still have to schedule an appointment. I mean, it really is the only way to cover your time.
Yeah, it really does have to be hourly because you don't know what you're going to be doing, and you don't know how in the weeds you need to get with them.
Because
And
it's a lot
here's
of,
the thing, even if they're not calling you all the time, you need to be reaching out to them every month. I generally, when I'm dealing with preparation of a business for bankruptcy, or I'm doing a dissolution, I go ahead and just set something on the calendar with my clients, like Friday at 10. That's when we're talking once a month, like the first Friday, because you want to remind them of the things that they should not be doing because they forget. And you want to be checking in. The one other thing I want to mention is you want to also be very careful about the ethical dilemmas when you have multiple owners. You want to let them know that you, you know, who do you represent? So think about it. And if you've got business owners who may be filing bankruptcy, I had one where they're like, we just want to talk to you about the business. And we get on the phone, or we get on Zoom, and all of the business owners are there, and the business has already been shut down. And now I have all the business owners and they want to talk to me about bankruptcy. And now, and each one of them filing a personal bankruptcy. One, I can't do that. And two, they have a conflict. So really be careful about who you're going to represent and what you're going to do with that.
also, you'll often get calls saying, I just want to put the business in a bankruptcy. I just want the
Right.
business to be what they really usually mean is I want the business to be responsible fully for this debt because I'm ready to close down the business or sell the business. And I personally don't want to have to deal with it afterwards, which is exactly the opposite of what they were asking for. In that situation, they're asking for personal relief, not relief for the business. And so then you have to carefully set your parameters as to who is your client. And I approach things a little bit differently than Lisa. So again, saying the EIDL consults or the SBA consults, my staff is trained to set those for paid consultations. The amount of people who call on those, it is simply unreasonable for me to have an ongoing, continuing attorney-client relationship with them. So for that purpose, like I have a one pager that I have clients sign before the consultation, where it's very clear that the parameters of our relationship is limited to that consultation. And guess what? The law is changing on a weekly basis. So if I talk to you in January and you call me again in March, things might be different.
Let me clarify. So I do a lot of business dissolution, as you guys know, and that is a specific thing to Arizona. So when I'm doing a business dissolution, it's like a private right to bankruptcy with no court oversight. So you do need to be talking to your clients. So if it's a dissolution for business, really do be checking in with your clients. But if you're getting ready to file a bankruptcy for them, just get the bankruptcy filed if you can.
Right,
Um,
right. Or if you just
yeah,
want
because I don't have that
information.
much time, you guys. So I didn't mean to like.
There's a lot of, well, what if I do this? Well, I
Mhm.
don't want that. So what if I do this instead? Well, what if I just sell the assets of the business? You can't do that. There's UCC lien. Well, what if I sell the business? Do I still have to pay the loan then? So there's just a lot of, well, there's a lot of explanations usually involved, and there's a lot of uh answering hypotheticals. So that's why I just treat them as completely separate
So I'm
isolated
going
movements.
to, so this is the information that you need to gather. I want to make sure that we get through all of our stuff and we're running a little short on time. You want to definitely check what your clients are telling you. You
Yes.
know, like have them get as much as they can, but you need to go and find out what's going on. In Arizona, we have a corporation commission. In California, it's the Secretary of State. Get what you can, find out if there's a UCC one. If you ask your clients if there's a UCC one, they're going to be like,
What's a
I don't know.
UCC
That's a
one?
UCC one. But if they do tell you no, like there might not be because they didn't ask you what it was, because that's usually the first question. All right, they can go to get information on the SBA website. Really the SBA is pushing everyone to use their website, which is why I was fascinated that I got a call, like, and an email.
So a lot of
Um,
those forms that we were mentioning, they get sent to the client through the My SBA
the
portal.
portal. So, Millie, you had a great this was your story.
Right. So I know we're running a little short, but let me just go back real quick for can we go back one? Yes. So for the My SBA loan portal, SBA's position it has been that everything goes through the loan portal or the address or contact information provided through the loan portal. However, sometimes if the borrower is in default, the loan portal or it's sent to the U.S. Treasury, the loan portal has been disabled, and so for that, we've been sending clients to the Freedom of Information Act website and having them file a claim through there so that they can get copies of their documents. Yeah, that was my bit.
That's a great point. Thanks for bringing that up.
All right. So, big question on how to advise the client depends on whether or not the SBA has a perfected security method. And so, luckily, we can check a lot of different public sources instead of trying to finagle documents from the client. If you can get documents, great, read them, that's great. But a lot of times, it's worth checking the um, the public resources available. So first and foremost, as Lisa said, there's the Corporations Commission, you said? Yes. And then Secretary of State in California. So you can check there first to see the status of the business, but also do a UCC search to see if there are any UCC liens pending. And then you can pull them up, read them, see the extent of it, because this is actually the first I've encountered this. A bank who underwrote an SBA 7A loan filed a UCC statement for the 7A loan and described the specific collateral it attached to, which was a piece of equipment. But then during the COVID EIDL loans, when they were being given out, the borrower applied through the SBA for an EIDL loan, got the proceeds from the EIDL loan, but at some point the SBA handed off servicing of the loan to that lender. And then the lender did something sneaky and filed a blanket UCC lien, which covered both the EIDL loan and the previous loan 7A loan proceeds. So just that way you get some clarity on one, is the UCC lien still timely? Has it lapsed? Two, what does it cover? Um, then next, I highly recommend checking your county recorders to see what, if anything, has been recorded against the property. A lot of times clients will think that they have pledged their home as collateral, and once you check the county recorder's records, you realize no, they have not. They have not executed something different that has been recorded in the chain of title. Um, for different kinds of lien perfection, also some types of lien perfections are handled through completely different entities. For example, SBA loans do not attach to vehicles through through blanket liens, because vehicle security is perfected through the DMV.
So as part of that, what I've been seeing is on COVID EIDLs, there's a blanket lien. There's zero security otherwise. It's just a UCC one. They have a company that's making a lot of money because they are keeping them renewed. I keep getting excited, like I look it up. We look up UCC ones in Arizona at our Secretary of State, just like you do. And I'm like, okay, maybe it's no longer there. Nope, caramba. Because they have a service that's doing it.
Right.
Um,
And we did have a brief period of like, hooray, the SBA is screwing up because they were not filing continuation statements for about for us it was like a 3 month period where no UCC liens were being continued, and
if
that
you're
was
in that
really tough.
window,
Right,
we're
right.
good.
And then also pay attention to your state's version of the UCC lien guidance, lien parameters, because for example, in California, you have to file the continuation statement within the 6 months preceding the expiration of the original UCC lien. So if you do not file it within that 6 month period, you file it before, you file it after, it's invalid.
Right. And they're going to, I mean, it'll be on record. So you have to, I mean, if you send something to the Secretary of State, they're going to put it out there. They don't, they're a ministerial body. So they don't make decisions as to whether or not this is valid or not. So you really
They
do
don't
have
have
to pay
skin in the
attention.
game.
Yeah, they don't. You paid them here. It's like you paid them $9. Cool. We'll put it, you know, I don't even know if you wrote it in crayon if they would reject it. So personal guarantees, we all know what these are. I think it's a really interesting issue as to on personal guarantees in a community property state. SBA historically has not had spouses sign. I was telling Milie about one that I had where it wasn't a COVID EIDL, it was an actual just regular, I don't remember if it was a 7A or a 504, but they made my client get an LLC. It was a single member LLC. The wife owned it and they never had the husband sign anything. And so I thought it was a really interesting community property argument that I was running with the offer and compromise. And then they moved to Colorado. So they ruined my ability to figure out if that would work. So I think that you can look at personal guarantees, and if they're invalid, if the spouse didn't sign, I, you know, the case law on this is, I mean, in Arizona, we have a statute that specifically says that you can't bind the community unless both spouses have signed on any kind of guarantor relationship. Um, how you would enforce that or use that is, I'm just giving you something in your quiver to think about. Um, so didn't we already have this slide? Uh,
Yes.
okay, well, we thought it was really important and we're going to skip it. This is the new alleged hardship program for EIDLs that I just learned about from one of my clients. So prior, as Milie was saying, you could go to the SBA. There was it an application? I think it was an application that
It
you
was an
did.
application, but it really was just more like clicking some buttons on a website. You really
Right.
didn't have to put in much information.
But you could do it on their website and then they would give you, the relief. Now, if you can find the buttons to click on the website, um, borrowers can get 6 months of half of their regular monthly payment if they state that there is only a temporary problem with making the full repayment, that if they have the reduction in payment for 6 months, it's going to allow full payment after this temporary reduction. And they agree that they understand that they will not receive another reduction in payment for the next 5 years. Huh? Like how possibly, I mean, that is a nice short-term issue, but um that is not going to fix the problem, right?
It's also asking you to predict your future and then
Well, I
bind.
think it's a gift to bankruptcy attorneys because I mean,
Sure.
it's neat. Like, okay, so free up some money so maybe you can do some things to increase your business, but what if it doesn't work? And as we all know, most business owners aren't like, yay, I get to file bankruptcy and shut down my business. They're really trying to make it work. I just don't see this as any kind of mechanism to fix things. And they're really, in my opinion, forcing people to file a bankruptcy.
So the SBA's official position is that they want to work with business owners who are struggling. They do. They want to work with you um to get your business back on track because they invested taxpayer money in your business and they are invested in making your business work. My response to that is good luck getting them to answer the phone. Good luck getting them to answer your emails. Um, yeah.
Unless you're me and you didn't want to talk to them in the first place. So maybe just throw that out there to the universe.
I think it was because yours wasn't an EIDL.
No, this is an EIDL.
Oh, okay. All right. I
Yeah.
think for EIDL loans in general, what I am seeing is that you are not going to get a response until you have basically admitted something like, um, I'm selling my business assets for X amount of money. Then you might get a response. But generally speaking, my clients have not had success in reaching anyone at the SBA or the specific branch of the EIDL loan center. Yeah.
So this is really specific for Arizona. And if you're interested in Arizona state law business dissolution, you are welcome to reach out to me and I will talk you through it. And there's also a presentation that I did for ACBC that should be on the YouTube channel that you can watch if you're interested in it. Uh, I have never had SBA respond to my notices during a dissolution, ever. I've sent them to, you know, Denise Falk in Tucson, who's our AUSA. And she called me one time and she's like, "What is this about?" I'm like, "We're dissolving a business. It's for the Small Business Administration." And she said, "Okay." And she sent it to them and then I never heard anything. So, um, contact me if you're gonna deal with it that way. Uh, so the offer and compromise, I think we kind of handled this.
Yeah. And I just realized how many slides we have left. So yeah, offer and compromise, they're not available for EIDLs. And for other types of SBA loans, they're very hard. If you think an offer and compromise is your only way to proceed, check for Chapter 11 Chapter 11 eligibility. That is usually the only way I'm successful with an offer and compromise.
So it, the Small Business Administration does not play let's make a deal. Like they don't. Like clients are gonna be like, why won't they take pennies on a dollar? Bird in hand is better, all of that. Yeah, okay. I won't even entertain that because it's not gonna happen and I don't want to take someone's money for it. Um, you can look at cramming down a secured debt in a bankruptcy, possibly, but again, I think you would be looking at filing for the business itself, the
Yes.
bankruptcy. I did have an interesting question yesterday about what if that business is a sole proprietorship? Like, so the loans to the sole proprietorship, and I mean, like, if you file a personal bankruptcy, could you cram down
Well,
the,
yeah.
I would say so
Say
after I
so.
thought about it.
Yeah. And
So,
the Supreme Court has ruled corporations, corporate entities are people, but not sole proprietorships. So I would say personal bankruptcy, yeah, you could do the cram down there.
so interesting idea. So, I mean, it pays to know about the business. EIDLs are fully dischargeable in bankruptcy. So if bankruptcy is an option for your client, I always say go there. If they want to maintain operations, they've got to go chapter 11, subchapter 5, shutting down chapter 7 or 13. And if they're unsure, you can hang with them and see what happens and then possibly do the bankruptcy. But as you guys know, if you hear me talk, prepare as though you're filing bankruptcy so you're ready to go. Um, the One of the things that you can do is just shut down that business, whether you do a formal dissolution like I do with some of my clients under the laws of Arizona. Shut it down either through that process or just terminate it. You can do that as well, and then file a personal bankruptcy for the owners, get the discharge of the SBA debt listed. I mean, I don't care how much, even if they get $25,000, make sure you list it. I mean, we always notice everything, even if we don't think that it's a debt. Um, but the downside is the SBA is going to send your clients notices forever and ever and ever and ever. Like they're going to continue to send notices and they're going to the business. They're not coming after your client personally. So there's nothing you can do. And you're going to have to tell your client. Otherwise, your client's going to contact you every month and be like, they sent me this. It's a violation, but it's not because they're sending it to the business. So,
And even if the business has been formally dissolved, your client's still going to get the notices. Yeah.
and yeah, they don't pick that up. I have my clients send their termination, if it was an LLC, their certificate of termination, as well as their discharge and bankruptcy just every time.
Doesn't
And
matter.
it's maybe someday someone will get bored and update the records. Who knows? These are the tips that I have for filing, a business owner bankruptcy. And what I'm talking about is a personal bankruptcy for someone who's owned a business. Um, and you guys can go ahead and look at this. It's in the materials. All right. Milie, how many chapter sevens have you done on these types of matters?
Very, very few. Usually the only time that a business will choose to do a Chapter 7 because of an EIDL loan is when the business has hit what I call
They're just done.
They're done. The business
And they
may
don't
still have some
care. They're
assets.
just like,
It may still be viable, but they've already put their hard-earned money, sweat, blood, tears, time, everything into it, and they just can't deal with it anymore. At that point, it's like, hey, why not give a Chapter 7 trustee a gift?
yeah, I'm not a big fan. And the reason is, we have different laws. We have the dissolution laws. But also I feel like, you may some of these businesses didn't keep the best records. So you might get a financial colonoscopy into what happened to bring you here. And, probably, nothing's going to come of it, but you still got to go through it. There's also the Chapter 13 bankruptcy. Those wouldn't be for a business, it's individuals only. But when I was filing bankruptcies, this was my area of practice. Because you could maintain business operations. I wasn't a big fan of that. I was a fan of shutting the business completely down, operating as a sole proprietor for a period of time, and then starting a new LLC. You got to be cognizant of the secured debt limit and also the unsecured limit. And keep this in mind, personal guarantees are not liquidated debt. So when you're looking at your secured debt limits, don't be freaked out because there's a personal guarantee, because they're contingent and they're unliquidated. So unless your client's getting sued, it's not a debt that is, I mean, it should be listed by all means, but you don't
Check
have
the
to worry
box.
about it blowing your debt limit.
Hmm.
I'm gonna let you do Chapter 11 because that's your
Whew.
bread and
Okay, so
butter.
Chapter 11, the best piece of advice I've ever gotten is if you're going to put a debtor into Chapter 11, make sure you have a plan to get the debtor out of a Chapter 11. Do not enter without knowing generally how you plan to exit. So, for Chapter 11, if the business is not, a lot of times you'll get a client that says, well, the business is still doing all right, it's still profitable. And then when you break down the numbers, you realize by profitable, they mean that they haven't been taking a paycheck and that there's only about $1,000 left a month. Not going to work. I know it's a hard pill to swallow, but at that point, your Chapter 7 or personal bankruptcy is the best option. So, Chapter 11 really only works if the business is doing well, but just has too much debt to pay at once. Generally speaking, the EIDL loan terms are not the worst in comparison to other types of loans that businesses may take out, like the merchant cash advance loans and some of those like Funding Circle and all those loans, or the ones that take daily draws. Yeah.
You mean the
So
creditors?
yeah, those are typically worse loans than the EIDLs, but just yeah, Chapter 11 is usually a good option the if you can do a subchapter 5, Chapter 11 may be a really good option for EIDL loans because, okay, yes, the UCC has a blanket lien, but what is actually of value with the business? Like if it's, for example, let's say it's a real estate office. So it's a realtor and they want to file a sub 5. What's the actual value of the business going to be? It's going to be accounts receivables or, pending sales, some office furniture, maybe a customer client list, maybe some branding. All of those things are very difficult to value. So you might be able to do a cram down. And in that sense, Chapter 11 may be a good option.
Well, and subchapter 5, one of the things that was really cool about it when it came out, well, individuals can file it, and in large part, a lot of them were filing it because they could eliminate an SBA lien on their primary residence, which was huge. I mean, you don't see those in COVID EIDLs, but on other loans where they've taken a lien on everything, including the family homestead, you can eliminate that in a subchapter 5, which is very cool because you
Right.
can't.
So, I mean, the main difference between deciding to do Chapter 11 or sub 5 is absolute priority rule. If you don't qualify for a sub 5, you got to pay attention to the absolute priority rule before even considering doing a regular 11.
So you want to notice, do you have any comments on this, Millie?
I do actually. So under the bankruptcy rules, make sure notice is sent to the right people. Um, but if you're doing some creative outside of bankruptcy solutions, it's not clear who you're supposed to service, who you're supposed to send notices to. I have taken to sending notices directly to the general counsel of the Small Business Association Administration in DC. It's worked out well.
Was that sarcasm?
No, it's worked out well because I'm noticing them in a way that I know they're not going to respond, and that's what I want.
I gotcha. So it has a little bit of sarcasm.
Yeah, a little bit. All right, so sometimes people got the money, didn't use it what they were supposed to use it for.
Get out of town. I'm glad I'm sitting down.
So, what are the consequences for that? Generally speaking, we have a couple of federal acts which govern the consequences. So, for example, False Claims Act, there's a criminal version and a civil version. So, before we mentioned that the SBA was sending out these alleged apply for EIDL loan forgiveness applications. Well, first of all, there has been no loan forgiveness outside of bankruptcy. Second, the forms that they did send out, they were the PPP loan forms where they erased PPP and wrote COVID EIDL. And there were several boxes that they provided that you could check as to the circumstance. Well, here's the thing. Some of those boxes, if you didn't read with an attorney's eyes, read the language carefully, you were admitting to misusing the funds and thus were liable under the False Claims Act. And I seriously think it was just a sneaky way to extend the statute of limitations that are coming up.
So there was actually a case recently that one point the bankruptcy court imposed an administrative penalty against a debtor of 1.5 times the principal of the EIDL, and it was some crazy amount of money, like I don't remember what it was. And so they do take it seriously. Definitely check to see, what your clients did with the money. It's not you want to know. And if you do have an issue, be upfront about it.
Yes.
Let's say they misspent $50,000. You want to be ready to deal with that and make some kind of deal. Diane, are you saying that our time is up?
Simply, I want you guys to finish. As you know, my philosophy is the more information we have, the better we are. I'm going to post the CLE certificate for those that want to grab it and leave. If you then please feel free to do that. Of course, the rest of us who are here to learn this stuff are going to stay. That was catty.
We're almost
Never
done.
mind. I'm going to send it. Okay.
Okay. All
I
right. So
also I also just posted my email address on there because I may not be able to stay as long as everyone wants. So please do not hesitate to reach out if you have questions or want to hear some more stories that might coincide with yours.
so again, honesty is the best policy. Own up to the mistake. There has been some issues, like when we were talking to the attorneys for the Ninth Circuit that represented SBA. They said the ones that they really went after, one, if you're looking at a really big um loan amount, you got to be really super careful about that. But then also the people who would just lie about it, you
Yeah,
know.
so generally I ask for an accounting. Okay, yeah, you got the loan. Full disclosure, how'd you spend it? Give us the accounting.
Do you I think most of these are yours.
Before you move to that, Scott has a question. Because I've heard this also, how aggressive is the SBA being on collecting these EIDL loans or their personal guarantees?
We don't know yet.
Okay.
I haven't seen any actions taken yet. I don't find them to, or I have not found them to be super aggressive in my bankruptcy cases. Like the they did show up at a 341 and said we want documents, and I said, okay, I'll get those to you. And then they were like, all right, and I did, and we were fine. So Milie?
In non-bankruptcy contexts, where a business is dissolving, we've been really careful about how we structure the dissolution of the business, and that's what I was talking about, sending notice to the general counsel for the SBA. Um, Here is an example. You have a commercial, or the business that you're representing has a commercial leasehold, and they cannot make rent payments anymore. They can't make those monthly payments. But they have a lot of equipment stored there that can't reasonably be moved, or requires a lot of expense, or there's nowhere for the business to store it. They're out of money. They can't buy storage space for it. And so in that situation, we've sent notices to the actual general counsel for the SBA saying, hey, business is closing. They can't afford this commercial lease anymore. There's this equipment here that technically you have a lien on, but client's not going to store it at their expense. So you have a UCC lien. If you want to exercise it, you have until this date. If we don't hear from you, then we're considering it abandoned and we're doing with it what we please.
And you're not going to hear anything.
Not gonna hear anything. I haven't yet. It's worked out really well, actually.
The, I mean, I had clients that actually the piece of equipment was in their garage, and we tried and tried and tried to get permission to sell it. And I mean, it devalued in the time. It was like, hey, you know, um, luckily it was in their garage and they weren't paying for any kind of storage for it. So you guys can go ahead and read these real life case examples, because I know that Milie needs to leave. Um, the Do you have any other things that you want to say, Milie, before you have to go? Do we have any other questions? Here is Millie's contact information.
So I mean the takeaway, I guess, from all of this is that, well, first of all, the SBA, as far as how they're actually functioning, it is a cluster duck. We just don't know. Because there are so many different things that have changed there as far as act actual ability to service these loans, hiring third-party servicers, working with established lending partners. There's just there, so a lot of what we're advising for is about what might happen in the future after you think you're done with this. So that's what a lot of my advice has been based on. Um, and that is where usually the personal bankruptcy ends up being the best option, because regardless of what happens to the business or meager business assets, at least the individual is protected by the bankruptcy discharge. And also, they don't have the manpower to go after all the debtors who did perhaps use the funds for less than permitted purposes. So have the documents to back up how the loan proceeds were spent, and do a balance test. Is the discharge worth a potential follow-up from the Department of Justice?
They were talking about doing carve outs when we had talked to them the last time. Like they would carve out, like, okay, well, you can have your discharge for this amount, but not this amount. And I don't know how you do that, because there's a part of me where I don't want to do the SBA's work for them. Like if I have something that's ugly, um, I'm not suggesting lie about it, but I don't want to be like, hey, you guys should really look at this. Like,
Yeah.
do you want some documents? Let me give them to you. I don't really want to provide that. But on the other hand, I think that you should be forthright about it if you get, if they ask, right? Like, so put
Yeah.
it in your document, put it in your schedules and say, this is schedule F, or this is schedule, whatever you're going to do with it. And if they ask you for documentation, be ready and advise your client, like, that boat you bought, yeah, that's going to be a problem, and you're not going to be able to walk away from that. So,
Just a real life example of where it's borderline, and again, get the documents. Client used EIDL loan funds to remodel a portion of his mother's house, alleging that he's going to be running his business out of the remodeled portion, but he's also living there. So a lot of ifs and maybes and probably nots there. So just get all the documents, get divide up what was used for what. Try to do your best to divide what's business versus personal.
Fabulous
um,
program. I'm sorry, Lisa, go ahead.
I was just looking at questions.
Oh, okay. That was the only one I see was Scott's about how aggressive.
Yeah, and who knows?
Yeah,
Like,
exactly.
I mean,
So
it changes all the time.
what I'm thinking is that maybe in another year, we'll ask you guys to come back and do us an update of what you found, etc. Because this is not going away.
Oh no, you guys are gonna see it. I They're gonna have to, in my opinion, come up with some kind of real and meaningful hardship program, or people are just gonna have to file bankruptcy. There's just not gonna be another option.
Yeah, I mean this is pretty much getting in line with hey, what's going on with student loans right now? We don't know. So I mean it's kind of in that pot where something should be happening in the background. We don't know what. And in the meantime, you get the one thing that you can rely on, which is a bankruptcy discharge.
Right. Well, I have posted the CLE certificate. I'll post it yet again. And if for some reason you're not able to download it from here, no problem. Just contact me at admin@acbcforum.org. Admin@acbcforum.org. So ladies, thank you. I know this is all bad news as far as we don't have any actual answers. But I have to agree with you. Bankruptcy seems to be the only way of being able to give these people relief at this stage. So anyway,
And Millie, thank you so much for,
yes.
like, thank you for being on a
My
panel with
pleasure.
me again.
We'll take any
Anytime.
excuse to hang out with Lisa, and it is my pleasure to, talk about this. Please do reach out if you have questions or have a situation you're not sure how to deal with. We've been able to come up with some really creative workarounds, uh, and it does give some sense of finality to the debtor who is agonizing over this. So,
All right, ladies, thank you. Again, this will be recorded. You all then can come back and listen to it. For those who listened to what I already did, I blew the first part of the recording for a couple of minutes, so you started. I
So we can
apologize.
just put our own in there.
Yeah, we could just put our own in. You got
I
it.
mean, it was just me trying to talk about myself, so I don't think anyone knows.
All right. Well, everybody take care. Have a great weekend and see you on the other side. Okay.
All right.
Hi, everyone.
Thank you.
Bye.